The Dormant Commerce Clause, also known as the negative Commerce Clause, is a legal doctrine that courts in the United States have inferred from the Commerce Clause in Article 1 of the United States Constitution. The Commerce Clause expressly grants Congress the power to regulate commerce among the several states. The idea behind the Dormant Commerce Clause is that this grant of power implies a negative converse, a restriction prohibiting a state from passing legislation that improperly burdens or discriminates against interstate commerce. The restriction is self-executing and applies even in the absence of a conflict between state and federal statutes, but Congress may allow states to pass legislation that would otherwise be forbidden by the Dormant Commerce Clause. The premise of the doctrine is that the U.S. Constitution reserves for the United States Congress at least some degree of exclusive federal power to regulate commerce with foreign nations, and among the several states, and with the Indian tribes. Therefore, individual states are limited in their ability to legislate on such matters. The Dormant Commerce Clause does not expressly exist in the text of the United States Constitution. It is, rather, a doctrine deduced by the U.S. Supreme Court and lower courts from the actual Commerce Clause of the Constitution. Origin of the doctrine. The idea that regulation of interstate commerce may to some extent be an exclusive federal power was discussed even before adoption of the Constitution, though the framers did not use the word dormant. On September 15, 1787, the framers of the Constitution debated in Philadelphia whether to guarantee states the ability to lay duties of tonnage without congressional interference, in order for states to finance the clearing of harbors and the building of lighthouses. James Madison believed that the mere existence of the Commerce Clause would bar states from imposing any duty of tonnage. He was more and more convinced that the regulation of commerce was in its nature indivisible and ought to be wholly under one authority. Roger Sherman disagreed. The power of the United States to regulate trade being supreme can control interferences of the state regulations when such interferences happen, so that there is no danger to be apprehended from a concurrent jurisdiction. Sherman saw the commerce power as similar to the tax power, the latter being one of the concurrent powers shared by the federal and state governments. Ultimately, the Constitutional Convention decided upon the present language about duties of tonnage in Article 1, Section 10, which says, "No state shall, without the consent of Congress, lay any duty of tonnage." The word dormant, in connection with the Commerce Clause, originated in dicta of Chief Justice John Marshall. For example, in the case of Gibbons v. Ogden, 22 U.S. 1, he wrote that the power to regulate interstate commerce can never be exercised by the people themselves, but must be placed in the hands of agents or lie dormant. Concurring Justice William Johnson was even more emphatic that the Constitution is altogether in favor of the exclusive grants to Congress of power over commerce. Later, in the case of Wilson v. Blackbird Creek Marsh Co., 27 U.S. 245, Chief Justice Marshall wrote, "We do not think that the act empowering the Blackbird Creek Marsh Company to place a dam across the creek can, under all the circumstances of the case, be considered as repugnant to the power to regulate commerce in its dormant state, or as being in conflict with any law passed on the subject." If Marshall was suggesting that the power over interstate commerce is an exclusive federal power, the Dormant Commerce Clause doctrine eventually developed very differently. It treats regulation that does not discriminate against or unduly burden interstate commerce commerce as a concurrent power rather than an exclusive federal power, while treating regulation that does to those things as an exclusive federal power. Thus, the modern doctrine says that congressional power over interstate commerce is somewhat exclusive, but not absolutely exclusive. This approach began in the 1851 case of Cooley v. Board of Wardens, in which Justice Benjamin R. Curtis wrote for the court, either absolutely to affirm or deny that the nature of this power requires exclusive legislation by Congress, is to lose sight of the nature of the subjects of this power, and to assert concerning all of them what is really applicable but to a part. The first clear holding of the U.S. Supreme Court striking down a state law under the Dormant Commerce Clause came in 1873. Effect of the doctrine. Justice Anthony Kennedy has written that the central rationale for the rule against discrimination is to prohibit state or municipal laws whose object is local economic protectionism, laws that would excite those jealousies and retaliatory measures the Constitution was designed to prevent. Quote, in order to determine whether a law violates a so-called dormant aspect of the Commerce Clause, the court first asks whether it discriminates on its face against interstate commerce. In this context, discrimination simply means differential treatment of in-state and out-of-state economic interests that benefits the former and burdens the latter. Thus, in a dormant Commerce Clause case, a court is initially concerned with whether the law facially discriminates against out-of-state actors or has the effect of favoring in-state economic interests over out-of-state interests. Discriminatory laws motivated by simple economic protectionism are subject to a virtually per se rule of invalidity. City of Philadelphia v. New Jersey 437 U.S. 617, Dean Milko v. City of Madison, Wisconsin 340 U.S. 349, Hunt v. Washington State Apple Advertising Com. 432 U.S. 333, which can only be overcome by showing that the state has no other means to advance a legitimate local purpose. Maine v. Taylor 477 U.S. 131. See also Brown Forman Distillers v. New York State Liquor Authority 476 U.S. 573. On the other hand, when a law is directed to legitimate local concerns, with effects upon interstate commerce that are only incidental, that is, where other legislative objectives are credibly advanced and there is no patent discrimination against interstate trade, the court has adopted a much more flexible approach, the general contours of which were outlined in Pike v. Bruce Church Inc. 397 U.S. 137, 142 and City of Philadelphia v. New Jersey 437 U.S. at 624. If the law is not outright or intentionally discriminatory or protectionist, but still has some impact on interstate commerce, the court will evaluate the law using a balancing test. The court determines whether the interstate burden imposed by a law outweighs the local benefits. If such is the case, the law is usually deemed unconstitutional. See Pike v. Bruce Church Inc. 397 U.S. 137. In the Pike case, the court explained that of state regulation having only incidental effects on interstate commerce will be upheld unless the burden imposed on such commerce is clearly excessive in relation to the putative local benefits. 397 U.S. at 142, 90 S. Court at 847. When weighing burdens against benefits, a court should consider both the nature of the local interest involved and whether it could be promoted as well with a lesser impact on interstate activities. Id. thus regulation designed to implement public health and safety, or serve other legitimate state interests, but impact interstate commerce as an incident to that purpose, are subject to a test akin to the rational basis test, a minimum level of scrutiny. See Bibb v. Navajo Freight Lines, Inc. In USA Recycling, Inc. v. Town of Babylon, 66 F3D 1272, 1281, 1995. The court explained, if the state activity constitutes regulation of interstate commerce, then the court must proceed to a second inquiry, whether the activity regulates even-handedly with only incidental effects on interstate commerce, or discriminates against interstate commerce. As we use the term here, discrimination simply means differential treatment of in-state and out-of-state economic interests that benefits the former and burdens the latter. The party challenging the validity of a state statute or municipal ordinance bears the burden of showing that it discriminates against, or places some burden on, interstate commerce. Hughes v. Oklahoma, 441 U.S. 322, 336, 99 S. Court 1727, 1736, 60 L. ed. 2d 250. If discrimination is established, the burden shifts to the state or local government to show that the local benefits of the statute outweigh its discriminatory effects, and that the state or municipality lacked a non-discriminatory alternative that could have adequately protected the relevant local interests. If the challenging party cannot show that the statute is discriminatory, then it must demonstrate that the statute places a burden on interstate commerce that is clearly excessive in relation to the putative local benefits. Minnesota v. Cloverleaf Creamery Co. 449 U.S. 456, 471. State taxation. Over the years, the Supreme Court has consistently held that the language of the Commerce Clause contains a further negative command prohibiting certain state taxation even when Congress has failed to legislate on the subject. Examples of such cases are Quill Corp. v. North Dakota, 504 U.S. 298, Northwestern States, Portland Cement Co. v. Minnesota, 358 U.S. 450, 458, and H.P. Hood and Amp Sons, Inc. v. Dumont, 336 U.S. 525. More recently, in the 2015 case of Comptroller of Treasury of M.D. v. Wynne, the court addressed Maryland's unusual practice of taxing personal income earned in Maryland, and taxing personal income of its citizens earned outside Maryland without any tax credit for income tax paid to other states. The court held this sort of double taxation to be a violation of the Dormant Commerce Clause. The court faulted Justice Antonin Scalia's criticism of the Dormant Commerce Clause doctrine by saying that he failed to explain why, under his interpretation of the Constitution, the Import-Export Clause would not lead to the same result that we reach under the Dormant Commerce Clause. Application of the Dormant Commerce Clause to state taxation is another manifestation of the court's holdings that the Commerce Clause prevents a state from retreating into economic isolation or jeopardizing the welfare of the nation as a whole, as it would do if it were free to place burdens on the flow of commerce across its borders that commerce wholly within those borders would not bear. The court's taxation decisions thus reflected a central concern of the framers that was an immediate reason for calling the Constitutional Convention, the conviction that in order to succeed, the new Union would have to avoid the tendencies toward economic balkanization that had plagued relations among the colonies and later among the states under the Articles of Confederation. Wardair Canada, Inc. v. Florida Department of Revenue, 477 U. S1 Hughes v. Oklahoma, 441 U.S. 322, Oklahoma Tax Commission v. Jefferson Lines, Inc., 514 U.S. 175. Formalistic approach. As with the court's application of the Dormant Commerce Clause to discriminatory regulation, the pre-New Deal court attempted to apply a formalistic approach to state taxation alleged to interfere with interstate commerce. The history is described in Oklahoma Tax Commission v. Jefferson Lines, Inc., 514 U.S. 175. The command has been stated more easily than its object has been attained, however, and the court's understanding of the Dormant Commerce Clause has taken some turns. In its early stages, the court held the view that interstate commerce was wholly immune from state taxation in any form, even though the same amount of tax should be laid on commerce. This position gave way in time to a less uncompromising but formal approach, according to which, for example, the court would invalidate a state tax levied on gross receipts from interstate commerce, or upon the freight carried in interstate commerce, but would allow a tax merely measured by gross receipts from interstate commerce as long as the tax was formally imposed upon franchises, or in lieu of all taxes upon property. Dissenting from this formal approach in 1927, Justice Stone remarked that it was too mechanical, too uncertain in its application, and too remote from actualities to be of value. Decline of formalism. Accompanying the revolution in approach in the court's congressional powers jurisprudence, the New Deal court began to change its approach to state taxation as well. The Jefferson Lines decision continues. In 1938, the old formalism began to give way with Justice Stone's opinion in Western Livestock v. Bureau of Revenue, 303 U.S. 250, which examined New Mexico's franchise tax, measured by gross receipts, as applied to receipts from out-of-state advertisers in a journal produced by taxpayers in New Mexico but circulated both inside and outside the state. Although the assessment could have been sustained solely on prior precedent, Justice Stone added a dash of the pragmatism that, with a brief interlude, has since become our aspiration in this quarter of the law. The court explained that it was not the purpose of the Commerce Clause to relieve those engaged in interstate commerce from the just share of state tax burden, even though it increases the cost of doing the business. During the transition period, some taxes were upheld based on a careful review of the actual economic impact of the tax, and other taxes were reviewed based on the kind of tax involved, whether the tax had a nefarious impact on commerce or not. Under this formalistic approach, a tax might be struck down, and then repassed with exactly the same economic incidence, but under another name, and then withstand review. The absurdity of this approach was made manifest in the two Railway Express cases. In the first, a tax imposed by the state of Virginia on American business concerns operating within the state was struck down because it was a business privilege. Tax imposed on the privilege of doing business in interstate commerce. But then, in the second, Virginia revised the wording of its statute to impose a franchise tax on intangible property in the form of going concern value as measured by gross receipts. The court upheld the reworded statute as not violative of the prohibition on privilege taxes, even though the impact of the old tax and new were essentially identical. There was no real economic difference between the statutes in Railway Express I and Railway Express II. The court long since had recognized that interstate commerce commerce may be made to pay its way. Yet under the Spectre rule, the economic realities in railway express became irrelevant. The Spectre rule had come to operate only as a rule of draftsmanship, and served only to distract the courts and parties from their inquiry into whether the challenged tax produced results forbidden by the Commerce Clause. The death knell of formalism occurred in Complete Auto Transit, Inc. v. Brady, 430 U.S. 274, which approved a Mississippi privilege tax upon a Michigan company engaged in the business of shipping automobiles to Mississippi dealers. The court there explained, appellant's attack is based solely on decisions of this court holding that a tax on the privilege of engaging in an activity in the state may not be applied to an activity that is part of interstate commerce. C.E.G. Spectre Motor Service v. O'Connor, 340 U.S. 602, Freeman v. Hewitt, 329 U.S. 249. This rule looks only to the fact that the incidence of the tax is the privilege of doing business. It deems irrelevant any consideration of the practical effect of the tax. The rule reflects an underlying philosophy that interstate commerce should enjoy a sort of free trade immunity from state taxation. Complete Auto Transit is the last in a line of cases that gradually rejected a per se approach to state taxation challenges under the Commerce Clause. In overruling prior decisions which struck down privilege taxes per se, the court noted the following: in what has become a central component of Commerce Clause state taxation jurisprudence, we note again that no claim is made that the activity is not sufficiently connected to the state to justify a tax, or that the tax is not fairly related to benefits provided the taxpayer, or that the tax discriminates against interstate commerce, or that the tax is not fairly apportioned. These four factors, nexus, relationship to benefits, discrimination, and apportionment, have come to be regarded as the four complete auto transit factors applied repeatedly in subsequent cases. Complete auto transit must be recognized as the culmination of the court's emerging Commerce Clause approach, not just in taxation, but in all of its aspects. Application of complete auto transit to state taxation remains a highly technical and specialized venture, requiring the application of Commerce Clause principles to an understanding of specialized tax law. Taxation of international commerce. In addition to satisfying the four-pronged test in complete auto transit, the Supreme Court has held state taxes which burden international commerce cannot create a substantial risk of multiple taxation and must not prevent the federal government from speaking with one voice when regulating commercial relations with foreign governments. Japan Lines Limited, v. County of Los Angeles, 441 U.S. 434. Incraft Gen. Foods, Inc. v. Iowa Department of Revenue and Finance, 505 U.S. 71. The Supreme Court considered a case in which Iowa taxed dividends from foreign subsidiaries, without allowing a credit for taxes paid to foreign governments but not dividends from domestic subsidiaries operating outside Iowa. This differential treatment arose from Iowa's adoption of the definition of net income used by the Internal Revenue Service. For federal income tax purposes, dividends from domestic subsidiaries are allowed to be exempted from the parent corporation's income to avoid double taxation. The Iowa Supreme Court rejected a Commerce Clause claim because Kraft failed to show that Iowa businesses receive a commercial advantage over foreign commerce due to Iowa's taxing scheme. Considering an Equal Protection Clause challenge, the Iowa Supreme Court held that the use of the federal government's definitions of income were convenient for the state and was, rationally, related to the goal of administrative efficiency. efficiency. The Supreme Court rejected the notion that administrative convenience was a sufficient defense for subjecting foreign commerce to a higher tax burden than interstate commerce. The Supreme Court held that a state's preference for domestic commerce over foreign commerce is inconsistent with the Commerce Clause even if the state's own economy is not a direct beneficiary of the discrimination.